All right. Good morning, everyone, and welcome to episode 16 of Sprout HR Express Season 6. So, I'm Simra, and I'll be your host for today. So, thank you so much, guys, for joining in this Tuesday morning. So, we'll be talking about authorized cost termination. So, if you like webinars like this, please don't forget to follow our social media pages at Sprout HR Tech and be on the lookout for all new episodes. We're also live on YouTube and Facebook as of this moment. So, just to give you a quick introduction of who we are, Sprout Solutions is the leading HR and payroll solutions provider in the Philippines that aims to help businesses transform and automate their HR processes. So, just like the new normal of virtual festivities and Philippine spirit, we celebrate innovations by helping your business adapt digitally. So, once again, a hearty welcome to everyone tuning in this exciting episode by Sprout Solutions. So, I'm sure you guys are looking forward or curious about today's topic, but later on we'll go ahead and tap on it. So I'll give you guys a quick icebreaker at the moment. So there will be a poll showing up to your screen in a while, and you guys can go ahead and answer the question. So hold on. Let me go ahead and launch the poll here. There we go. I think the poll showed up to your screens. So just check it out. Here are the Here's the question. So, what do you do to discipline employees? First off, there is an answer here. Well, give a performance improvement plan or PIP. Second is have regular one-on-one session with the employee. Third is have other teammates talk to the employee. And fourth is set a disciplinary action meeting. So you can guys go ahead and click the most accurate one that you prefer or you think is the best option to discipline an employee. Okay, I'll give you guys for like a minute. I think all of the above are actually effective. So it actually depends on what disciplinary action that you need to take, or if it's like really grave or how big of a mistake that the employee made. Perhaps you can go ahead and just do a one-on-one session with the employee and see what happened on it. Or you can guys go ahead and talk to the employee before having a disciplinary action. So it actually depends. Okay, just like 5 seconds in, I think a total of 35 voted on this. Okay. Okay, all right. I'll just go ahead and end the polling. Thank you so much, guys, for answering the question here. So 57% have regular one-on-one session with the employee, while Checking out here, 22% give a performance improvement plan, and also 22% set a disciplinary action, while no one answered the third, which is have other teammates to talk to an employee. So, which is actually true. There we have it. I'm just going ahead and share it out. There we have it. All right. Thank you so much, guys. So, aside from the icebreaker, I have a raffle prepared for you guys. So, let's start spicing things up. So, for those who have already joined our previous webinar, you already know what our raffle is. But for those who haven't, it is your first time, here is the raffle mechanics that we'll be providing for you. So, first is collect all three keywords that will be flashed onto your screen throughout the webinar. Second is follow Sprout's official Twitter page at Sprout Asia Tech. Third is comment all three keywords on the pinned tweet on your Twitter page. Sorry. And then fourth will be we'll announce the lucky winner at the end of this session. Lastly, we'll be sending the prizes via Twitter DM after this session. So again, guys, you have to collect draw all three keywords and get the chance to win 200 peso Grab gift card. 200 pesos is a lot already. So first up, here is the first keyword for you guys, which is etiquettes. Again, it will be showing up to your screens now. There we have it. It's etiquettes. So the first raffle keyword is etiquettes. Okay, so while you guys are logging into your Twitter accounts, I just want to let you know there will be a fireside chat session wherein you can ask our panelists or our speaker rather about today's topic, which is the art and law of letting go. Again, guys, the art and law of letting go. So I'm actually really curious already of what our speaker will talk about on this. So we'll go ahead and proceed with that. So just go ahead and start listing down your questions later on, and we'll go ahead and address it after our speaker's talk. So, speaking of the speaker, I'd like to introduce to you to I have to introduce you our speaker for today. So, he is the head of business development and legal counsel of Sprout and fellow of Arellano University School of Law Center for Legal Education and Research. So, everyone, please give him a round of applause, Attorney Lester Ople.
Hi, good morning, everyone. Thank you for your introduction, Samira. And I'd like to just go back to the earlier poll, no? Napansin niyo dun sa poll, we were talking about discipline. Let's take note that for employee discipline, there's always two approaches. That is the carrot and the stick. The carrot talks about rewards, and the stick talks about punitive actions or punishments or penalties. There is no single action that will enable you to penalize, or there's no single stick when you talk about employee discipline, no. There's progressive discipline, there's performance management, and of course there is the learning and management, no, because you cannot discipline an employee if he is not properly equipped with the tools or the knowledge for doing his job. So kailangan holistic ang approach natin to discipline. But for this topic, for this webinar's topic, we will be talking about authorized cause dismissal of employment. I call this the art and law of letting go because there is both a law, a legal aspect, and there is an art, which is how we actually execute the dismissal of employment for authorized causes. Okay, next slide, please. So let's talk about the recent IATF resolutions. NCR is now placed on ECQ from August 6 to 20. And starting July 30, there were actually reductions on operating capacities of all the dining establishments and other businesses that are affected. All of these are in line with the omnibus guidelines implementing the community quarantine in the Philippines, which is another IATF resolution. No? And from August 6 to 20, the ECQ guidelines will apply, which means that only essential industries will be allowed to operate. Meaning, ang ating mga kababayan who are in the food service industry, in the personal care industry, all of these are not allowed to operate for another period of 2 weeks. And we are hopeful that this will be the last, at least for 2021, because we are now seeing the wave, no, of COVID infections again rising up, no. And on a personal note, I share this quite well. I was actually a COVID patient, severe COVID patient in April. Thankfully, I was able to come out of it unscathed, and hindi nga po halata sa akin, no, na I was a severe COVID patient. But there are a lot of other people who are not as lucky as I am. I was lucky enough to have access to medical facilities at that time, and now this topic is really close to my heart, because not all businesses are properly equipped with how to properly and lawfully let go of their employees when needed. Next slide, please. So this is a slide, or rather a photo from Arnold Padilla on Twitter, and this shows how many are the affected employees, no, employees in the major industry groups. As you can see, there's about 152,000 employees already affected, and this is only for the period of until July 30. No, so imagine if we have around 600,000 employees in a particular location. No, there are already 152,000 employees who are now part of the statistics of unemployed. And hopefully, all of these employees who have been displaced due to permanent closure and reduction of workforce, we hope that they have been properly handled by their respective employers. So, how do we actually let go of employees in a lawful manner? Next slide, please. Okay, next slide, please. So let's talk about the legal basis first, no, of letting go of employees. It's 200, excuse me, 298 and 299 of the Labor Code of the Philippines as amended. This is the old, in the old numbering, it's 282 and 283. Excuse me. And of course, in implementing Articles 298 and 299 of the Labor Code, the Department of Labor actually issued Department Order 147 series of 2015, which gives the guidelines on how to actually effect a just cause and an authorized cause termination of employment. And of course, there are jurisprudence or cases decided upon by the Supreme Court where this particular question was actually asked, no, and these form the part of the legal basis of Department Order 147, and we review these jurisprudence or cases decided by the Supreme Court to make sure that whenever we actually effect an authorized cause termination, we do not commit the missteps that were pointed out by the Supreme Court. Next slide, please. Sorry, I correct myself. It's not 282 and 283. It's 283 and 284, no, in the old numbering. So this is 298, which refers to closure of establishment and reduction of personnel. Ito po yung codal definition as copied from the law itself. And 299, or the old 284, which is deceased as ground for termination. Okay. Next slide, please. So let me just go back to our comparison, no, regarding just cause and authorized cause dismissal of employment. When we talk about just cause termination, these are very specific grounds: serious misconduct, gross and habitual negligence, fraud, commission of a crime, and analogous causes. Additionally, there is a separate ground. Sinama ko na lang siya sa just cause for purpose of compressing it in one slide. There is also the ground of a probationary employee who fails to qualify for regular employment. Authorized cause, very specific grounds as well in the law. It's redundancy, closure of establishment, installation of labor-saving devices, and retrenchment. And of course, disease, which is again a separate item in the labor code. As to eligibility for separation pay, general rule in just cause termination, there is no such thing as separation pay, except of course if you have a company policy or employment contract that explicitly provides for compensation in the event of just cause termination. The other one, in authorized causes, all authorized cause terminations are eligible for separation pay. We will discuss the actual amount later. And due process requirements, magkaiba po. Sa just cause termination, you have to comply with the twin notice rule as explained by the Supreme Court in the case of King of Kings Transport versus Mamak, a 2007 case. And in authorized cause termination, it is the due process requirements are complied with by having two notices. The first notice to the DOLE, notifying them of the authorized cause, and of course to the employee. And additionally, for terminations due to disease, the certification of a public doctor. We will discuss this in further detail. Okay, next slide, please. Now we talk about installation of labor-saving devices. These are the elements called from Department Order 147 series of 2015, and these guidelines and elements called from this department order actually was derived from Supreme Court decisions. No? So when you talk about installation of labor-saving devices, these are the elements. Introduction of machinery, equipment, or other devices. The introduction must be done in good faith. The reason or the purpose for the introduction of such device is valid, meaning ang purpose dapat cost savings, efficiency gains, and other economic reasons. Fourth, there is no other option available to the employer and other than the introduction of the machinery and the consequent termination of employment of those affected thereby, and there must be fair and reasonable criteria in selecting employees to be terminated. Let's illustrate this. So, sa isang manufacturing plant, meron kayong, let's say, your assembly line of cars, no? Ang old production line ng kotse, na imagine ko si Henry Ford, yung kanyang first automobile factory, no? Production line yan. So, stage 1, stage 2, stage 3, dire-diretso, no? So, all of the workers in each stage of the manufacturing line will perform their particular process step in assembling the car, and then the car will move to the next stage. Nag-introduce ka ngayon ng, let's say, automated na taga-pintura. No? So, na-assemble na yung pinto, lahat ng yung hood, yung trunk, na tapos pipinturahan na lang yung kaha ng makina, ng kotse. Ngayon, yung taga-pintor mo, dalawa sila, kaliwa, kanan, before, no? With the introduction of a machinery na taga-pintura, automated, ngayon, your two people who are affected, 'di ba, good faith, kasi ang purpose mo ba't ka nag-introduce ng automated paint application machine is for you to get the efficiency gains, kasi hindi ka na magtutuyo, hindi ka na titimpla ng pintura, all of these things, no? And then you have two employees who are affected. These are the people who are actually painting the cars right now. So there is no other option now, no? Ngayon, ang pupuntahan mo ngayon for those two employees, number one, the first question you have to ask yourself is, can you actually retool them? Can you actually deploy them to another part of your business where their skills can be applied so that you do not need to terminate their employment? If yes, then yun yung hindi ka pwedeng mag-installation of labor-saving devices as an authorized cause termination. Better to retool them and deploy them to another aspect or line of the business so that you can avoid dismissing them from employment. Assuming after you review your organizational chart, wala na silang pwedeng paglagyan, puno na sa HR, puno na sa sa other aspects of the business, wala ka na ibang pwedeng paglagyan nila. No, pulo ka na sa org chart. There's no other area of the business where you can deploy these two affected painters. No, you now have no other option but to terminate these two employees. No? And ano yung fair and reasonable criteria? Ang ini-install mo na makina is paint applicator, automated. Hindi mo pwedeng yung nasa taas ng process yung i-terminate. Hindi pwedeng yung nagpupukpok ng, yung latero mo. Hindi pwedeng yun yung i-terminate natin. Kasi ang in-introduce mo na makina is specific to the application of paint. So that is the fair and reasonable criteria in selecting employees to be terminated. Okay? So I hope that illustration is clear. Let's move on to the next ground. Okay, redundancy. This is very common, no? This is very common, especially in the BPO industry. No? So, ano yung elements ng redundancy? There must be superfluous positions or services of employees. These positions or services are in excess of what is reasonably demanded by the requirements of the business. There is good faith. Mapapansin nyo sa lahat ng grounds ng termination dito, good faith is an absolute non-negotiable requirement. Fair and reasonable criteria, that's also a similar rule, no, across all grounds for authorized cause. And then adequate proof of redundancy. Ano example natin dito? 2007, let's go back to 2007. Noong 2007, you have 50 call center agents receiving receiving inbound customer service calls. Ngayon, come 2015, nagkaroon na ng technological advancement. Instead na 50 agents, nag-deploy kayo ng IVR or integrated voice response tool na bago pumasok sa human agent yung tawag, there is a screening that's performed by the IVR. Now, instead of requiring 50, you now notice that with the volume of calls that you receive, you can only support headcount of 30 people, no? 30 people from 50 naging 30. Dahil yung 20 na absorb na nung IVR yung volume ng lahat ng pwedeng screen na tawag. Okay. What do you now do with the 20 people? The first option, again, look for other places in the organization where you can deploy them. Can you retool them? Can you redeploy them? No? If you are unable to retool and redeploy them, then you now have the good faith. No, you were able to identify that particular group of agents. So, balik tayo sa fair and reasonable criteria. So, etong 20 agents na to, 50 yung agents mo ngayon, diba? Na ngayon, kailangan maging 30 na lang. Ano yung criteria na i-apply mo sa kanila? Number one, first criteria that the Supreme Court has allowed is last in, first out. Sino yung pinakabata, sila yung pwedeng i-terminate. Bakit? Kasi the presumption is yung right nila for that particular job has not yet deepened enough, kaya pwede pa silang i-let go. Second rule, performance. Ano yung performance? Meaning, historically, ano yung annual appraisal scores nila? Sino yung pinakamababa? Pwedeng sila yung unahin mo. Kahit pa sabihin, medyo maedad na yan. Okay? Ano pa yung pangatlo na pwede? Efficiency. Sino yung mababa ang average handling time? No? Of course, that will reflect to performance as well. No? And these are just samples of what the Supreme Court has allowed as criteria in identifying the employees to be redundated. Question, ang isang pasaway na ahente, eto mahilig, wala akong matira sa kanya performance kasi pumapasa siya. He meets the minimum requirements to stay in the account. Pero pasaway ito, eksakto yung break niya lagi. Pagka kailangan ng overtime, nakaka-dodge siya, hindi siya pwedeng mapa-overtime. Pagka rest day, holiday, hindi siya pwedeng matap kasi solo parent, yung mga ganyan. No? Can you actually massage the criteria so that particular employee will be affected in this redundancy? You go back to the rule of good faith and reasonable criteria. No, the criteria has to be applied blindly. Hindi pwedeng may tina-target ka na employee. No, and of course good faith. Kasi if the only reason for redundating an employee is attitude, medyo tagilid tayo dyan. That can be a ground for illegal dismissal. Kung yung criteria is minasahe para lang maging affected yung particular employee na yon, tagilid ka rin dyan. That can be a ground for a cause of action for illegal dismissal as well. Adequate proof of redundancy. Ano yung adequate proof natin? Ito, maraming nakakalimot na to. The adequate proof of redundancy has to be a paper trail. Imagine a paper trail that you actually start identifying the superfluous positions. Meron ka bang org chart? Meron ka bang tracking ng historical volume mo from 2007 to 2015? Meron ka bang performance ratings nila? No, if you do not have all of these paper trails, then it will be very difficult for you to prove the good faith in a redundancy situation. Okay? So this kind of situation is actually helpful. It will actually be helpful for you if you have a tool similar to Sprout kasi you can actually track, number one, your org chart. Number two, your performance ratings. Kasi if you do not have both, tagilid ka sa redundancy. Okay? Let's go to the next slide, please. Back, one slide back, please. Ayan, retrenchment. Ano pinagkaiba ng retrenchment sa redundancy? Simple lang. Ang retrenchment or downsizing, may business losses ka. Okay? Meaning, let's extrapolate similar to what we have right now. It's the ECQ. Last year, ang haba-haba ng ECQ natin. Some businesses actually have serious business losses. No? Some do not have serious business losses. Okay, so ano yung elements ng retrenchment or downsizing? Retrenchment is reasonably likely and necessary to prevent business losses. Number two, substantial yung losses mo. Hindi pwedeng de minimis lang. Hindi pwedeng reduced gross revenue lang. Kailangan negative ka sa financial statement mo. Third, expected or actual losses must be proven by sufficient and convincing evidence. I'll discuss the expected and actual in a bit. Fourth is good faith. Definitely hindi pwedeng mawala ang good faith. Across all grounds of authorized cost termination, requirement ang good faith. And again, fair and reasonable criteria. Okay, punta tayo sa restaurant establishment. No? Sa isang restaurant last year, panigurado nag-suffer kayo ng losses. Ngayon, ano yung degree ng losses nyo? If you were able to pivot in such a way that you actually were able to derive a lot of revenue from takeout or delivery transactions, then you may not have substantial losses. Alternatively, you may have losses in the side ng ng dine-in, no? Kasi reduced capacity. So hindi mo na kailangan ng instead na 10 ang waiter, kailangan mo na lang 3 or 5 na waiter. So ngayon, ano yung gagamitin mong ground? Retrenchment ba or redundancy? You go back to your paperwork. Do you have serious business losses? Because if you have serious business losses, you go retrenchment. If you do not have serious business losses, you go redundancy. Bakit? Kasi makikita natin yan pagdating sa separation pay. Now, there's a difference in the separation pay. Okay, next is yung ating expected or actual losses. Anong difference ng expected and actual losses? Kung maalala nyo last year, we also had a similar webinar where we were talking about flexible work arrangements, FWAs. No? As a response to the ECQ and the various permutations of community quarantine, we actually can do alternative work schemes. No? And the alternative work schemes allowed ang shifting, allowed ang rotation ng work. And if hindi pa rin kaya, you can actually use retrenchment using the expected losses. No? So you do a projection of your finances. If you can do a projection of your finances, that if your headcount or manpower remains at the similar level as it is now, you will not be able to sustain it. Now you have expected business losses because you can see may ECQ na ulit. Diba? So you can do your projection of your sales accordingly. Actual losses is nagsara na yung financial year, yung fiscal year. So you have an audited financial statement which you will submit to your BIR and or SEC, no, as the case may be, which will be actual proof of actual losses. Okay, let's go to the next slide, please. Closure or cessation of operations. This one is also different kasi there's closure or cessation of operations due to not serious business losses, meaning pareho yun na retrenchment, and then there is the serious business losses. So, anong rason bakit valid ang closure or cessation of operations? Because a business owner cannot be compelled by law to actually continue the business if there is no longer a desire to do so. No? Okay. And then disease. The disease, this one is a little controversial. So we may need a separate episode for this, dedicated for this lang. No? But these are the elements for disease. The employee must be suffering from any disease. The continued employment of the employee is prohibited by law or is prejudicial to the employee's health as well as to the health of the co-employees. And there is certification by a competent public health authority that the disease is incurable within a period of 6 months, even with proper medical treatment. Anong example nitong disease? Let's go to pulmonary tuberculosis. May mga stages ng pulmonary tuberculosis. This is the textbook example of a disease, no, as a ground for termination. Ang disease as a ground for termination of employment has to be prohibited by law or is prejudicial to the employee's health. So ang pulmonary tuberculosis can actually be managed. No? Meron tayong tinatawag ng mga DOTS, no? Yung directly observed TB something approach. This is the DOH methodology in line with the presidential decree for PTB management. And you also have to have a policy for PTB management in the workplace. So if the employee is suffering from a severe form of TB, which cannot be cured within a period of 6 months, then you get a certification from your public health authority. By ano yung competent, ano yung public health authority? Public health authority meaning hindi siya private doctor. Has to be someone from a from a government hospital, and competent meaning hindi siya, kunyari, kung ang pinapa-certify natin pulmonary tuberculosis, hindi pwedeng OB-GYN ang magbibigay ng certification. Kailangan pulmo or at the very least internal med. Or at the very least even yung general practitioner natin. This is the minimum requirement of the law, no? Hindi pwedeng biglang ibang ano pala siya, ang pinapa-certify natin, pulmonary tuberculosis, sa OB ka nang hingi ng certificate, malabo yun. And it's not curable within a period of 6 months, even with proper medical treatment. Again, disease and closure of cessation of operations, both of these grounds also have separation pay. Let's go to the next slide. Okay, ito yung pinaka-controversial. Payment of separation pay. Kailan 1 month of pay, kailan half month of pay, kailan not required. Okay, for installation of labor-saving device and redundancy, it has to be 1 month pay for every year of service or 1 month pay kung alin yung mas malaki. Pag retrenchment, closure of or cessation of business not due to serious business losses and disease, half-month pay for every year of service or 1 month pay, whichever is greater, and it is not required in just cause termination. I discussed it earlier, unless there is a more favorable company policy, and in closure or cessation of business due to serious business losses. Jurisprudential po yung number 2 sa not required, which is closure due to serious business losses. Simple lang yung rason ng Supreme Court. Ano pang ibabayad ng employer kung wala na nga siyang kinikita? Okay? Next slide, please. Now let's talk about the art. No, I know I'm very conscious of the time. So let's talk about the art of letting go. Kanina we discussed about the law. Now let's talk about the art. How do we actually implement it in front of the employee? Next slide, please. Ano yung process? No? Again, the process is twofold. You have a written notice to the employee at least 30 days before the effective date of dismissal, and you have a completed RKS Form 5 version 2020 to the Dole Field or Regional Office, again, 30 days before the effective date of dismissal of the employees. Ito pong RKS Form 5, nasa Dole website po ito. Please go to the Dole website, to the Dole Field or Regional Office having jurisdiction over your workplace. Look for the downloads page. Nandun po yung latest version ng RKS Form 5. Hindi na po ito yung dati na one-pager. Ngayon po, two-pager na siya. Plus the list of employees where specific personal information of affected employees is required. No? Piliin nyo lang po yung tamang code. Bakit importante yung tamang code sa RKS Form? Kasi magkakalituhan doon pagdating ng kasuhan. No, if you are complained for illegal dismissal, then your first line of defense is definitely the notices directed to the employee as well as to the dole. If you fail in giving the notice to the employee and to the dole, you are likely liable for illegal dismissal. Okay. Third, very important, is yung payment of separation pay in compliance with DOLE guidelines. Meron tayong requirement, no, nasa DOLE issuance na to. For COE and other post-employment documents, 3 days from the last day of employment, final pay 30 days. Pero personal opinion, having both executed and received, authorized cost termination in my time, I was part of a redundancy exercise in one of my previous employers before, and it was so funny because I was part of the planning initially kasi organizational change ito. The company was being acquired or merged with another company, and I was part of the first few meetings talking about the merger. And then I was removed from those meetings. Hindi naman unceremonious, but I said, okay, I might be affected. Intayin na lang natin. And true enough, I was. And I'm very thankful to that employer for having treated me with compassion. And sa kanila ko natutunan ng aking HR chops. No? So, ganito yung best practice. Release it the same day as the last day of work. Bakit? Kasi pinapaalis mo na yung empleyado. Diba? Don't add insult to injury by delaying your final payment. Okay? Again, the form of payment is, ano tawag nito? Should be check or cash. No? Hindi pwedeng promissory note. Kailangan legal tender. Okay, next slide, please. So, how do you actually let go of an employee, using authorized cost termination? You treat the authorized cost as a project. If you're talking about redundancy, retrenchment, or labor-saving devices, you actually have a project to implement, which is implementation of an organizational study or implementation of a technological device that will facilitate efficiency gains in the workplace. There should be a project in the deployment of that particular study, and then you should have a post implementation aspect which deals with the employees affected. No? So you treat this as a project. Meron kang start date, kailan natin sisimulan yung pag-study ng org chart, kailan natin sisimulan yung pag-study ng manufacturing process so we can implement the proper technological device which will increase our efficiency gains. Okay? So you treat this as a project hanggang makapag-release kayo ng final pay. Yun yung end date mo. And then even after that, you make contingency because you may be subject to a legal case, no? Because some employees will not take it well, and that's a fact in reality of life that we all have to deal with, no? So treat this as a project so that you are adequately prepared, resource-wise, and of course, um, documentation-wise. Number two, you treat the affected employees with respect, compassion, and fairness. Hindi pwedeng i-echaparahin mo lang yung concerns nila. If you're implementing an org study or a change in the process by introducing a manual, or ano tawag nito? Introducing a device that will implement efficiency gains, then you over-communicate, no? You treat them with respect na meron ka na dapat communication plan. Again, babalik tayo sa project. May communication plan ka na. How will employees take this change or this study, no? And then you treat them with compassion and fairness. Hindi pwedeng isisikreto lang natin yung implementation ng project natin tapos i-deploy natin tapos biglang mawawala na pala kaming trabaho. That is the start of legal risk when you do that to your employees. And third part is over documentation is key, no? Kailangan every step of the way kasi nga project to, may documentation ka, may paper trail ka, no? The better way of doing this is you start with a project, you have a presentation to your management regarding what will be implemented, and then hanggang dulo, nandun na yung resources na hinihingi mo sa kanila na i-commit. Very important that you ask your management to commit your resources for separation pay. And if your budget can allow it, especially in these trying times, make sure that you also have, a provision for financial assistance. In better economic circumstances, no, redundancies are actually welcomed by employees. But now with uncertainty of the pandemic, redundancy, even if meron kang makukuhang separation pay, it results in a lot of anxiety and mental anguish for employees dahil nga ang uncertain ng mga panahon ngayon. So over-document and over-communicate. Yan yung ating mga bilin para makapag let go with less pain. Okay? Next slide, please. Okay, that ends my presentation. Thank you so much for listening. Back to you, Samira.
All right. Thank you, Attorney Lester, for the topic. Now, I want you guys to give you the second raffle keyword. Okay, hold on. Maybe just prepare for it. All right. Okay. Our second raffle keyword is control. Again, the second raffle keyword is control. So just make sure to keep track of all the keywords, okay? So before I give you the third and final keyword, here at Sprout is in our culture to keep practicing work-life integration. So if you're down to learn more about us as a company, please take a look at this video.
So you've got your processes, and your company is an oiled machine that runs pretty smoothly, but under the hood, you have problems. You've got managers desperate to know the status of their open positions, leave requests getting lost in a jumble of emails, SMS and forms, and employees complaining about payroll errors. You've thought about some expensive custom software that would be a pain to maintain, or swimming in all the features of SAP or Oracle, or maybe even outsourcing your payroll altogether. Why can't you find a local, intelligent, well-supported software that caters to your needs as a Philippine company? Well, guess what? Here at Sprout, we've developed a system that just works. One system with all the features you need and without all those that you don't. So what are you waiting for? Get over to sprout.ph and get your systems fixed today.
All right, thank you so much, guys, for watching that video. So now, to finally announce the third raffle keyword. Okay, are you guys ready? Okay, the third raffle keyword is security. Again, it's security. I'll go ahead and give you a recap of the three keywords of our raffle, which is first etiquettes, second is control, and third is security. All right, again, guys, to join the raffle, simply follow our Sprout YouTube page at Sprout HR Tech and comment all these three keywords on our latest pin post. And so we'll be choosing our lucky winner later on after a fireside chat session. So speaking of our fireside chat session, go ahead and prepare for your questions. So I'd like to welcome back our speaker, Mr. Attorney Lester Ople. And so, guys, the floor is yours. We'll go ahead and answer the questions that you provided. Okay. The first one here, Attorney Lester, is in a BPO setup, if the client does not want the employee any longer and there are no accounts to accept the agent, what should we do?
In hindsight, I should have added the concept of floating, no, in the content. My focus for the presentation was really authorized cause termination, not the 6 month suspension of employment. If you remember last year, the Dole issued a Dole advisory regarding the 6 month suspension of employment. We call this in the BPO. I was a BPO HR person before, no. We call that the float. That means that for a maximum period of 6 months, you can put your employees on a floating status pending their assignment to a new account. Take note that this is a very dangerous practice. Why is it dangerous? Because if you breach the 6 month period and they have not been placed on any new account, you are now potentially liable for constructive dismissal. So you have to deploy them to an account before the 6 month period expires. Okay? So very specific yung timeline na yun, no? And then are there no accounts open to accept the agent? So you go back to your agent, no. Number one, why is the employee, why is the client, no, yung account, bakit ayaw na ng account do sa empleyado na yon? You check if that employee is still on probationary status, because if the employee is on probationary status and the employee actually fails to meet the standards for regularization, then you have the option to non-regularize that employee. Second option, if the employee is already regular, no, and the employee is adequately, kumbaga na breach na niya yung regular status kasi more than 6 months na siya, may security of tenure na siya, then you have the option number one to float. Number two, i-deploy siya sa ibang account. Question ng ibang account, do we treat that person as a probationary employee again, or do we treat that as a regular employee? You treat that person as a regular employee, no? Bakit? Kasi na-breach na yung probationary period, meaning regular na siya by law. So you are not actually allowed to treat that person as another probationary employment unless puputulin mo yung employment talaga, no? So I hope that this was helpful, anonymous attendee. My take there is you have to work hand in hand. Yung HR natin and the account management team of the BPO kailangan hand in hand, kasi dalawa yung kailangan nyo dyan. Number one is training to the employees. You retool them because there's no other option if they're already regular but to redeploy them. And number two is ano yung rason bakit ayaw na nung client. Remember that you are the employer, no, not the client. If you are letting your client select, then your client is actually performing a function of employment and wala silang legal entity dito, 'di ba? So you take a stand na the selection of employees is not up to the client 100%. Okay? I hope that was helpful.
All right, thank you, Attorney Lester. We have another question here with Mendoza. So on redundancy, is there a specific time frame where you can hire someone on a post which has been redundant? Is that right? This is
Yeah,
assuming there is an organization change that happened after the redundancy and the same position was defined as needed.
the delikado part there, no, delicate. Yung delikado na part dyan is kailan ka magkakaroon ng mawawalan ng good faith. Remember, across all authorized cause terminations of employment, the requirement is good faith. If after an employee was let go, after a short period of time, you implement an organizational change just to revive that position, then as counsel for that particular employee, I have the argument to actually tell you that you now lack good faith. That's an exercise of bad faith. So there is no hard and fast rule. Some people say it's 3 months, some people say it's 6 months. My take there is the moment that good faith can be challenged, that's the time that you cannot be challenged rather. That's the time that you can actually revive the position. So ano yung substantial change? Kunyari, nawala na bigla ang quarantine, no? That can be a substantial change in the economic. There's a separate module I do for HR strategy, no? When you do a pestle analysis ng political, economic, social, technological, legal aspect, kaya na bang i-challenge yung good faith? Kapag hindi na kayang i-challenge yung good faith, pwede na yan. Okay. That's
Okay,
it.
thank you
Yeah.
so. All right, thank you, thank you. There's another question. Terminating an employee due to just cause, example, a wall, will not need 30 days notice, right? Kindly confirm.
Our topic is authorized cause dismissal, no? You're talking about just cause dismissal. You go to your employment policies, your handbook, employee handbook. What's your process? Because some contracts of employment may have that kind of reservation. Before ka mag-terminate, even for just cause, kailangan may i-observe na period. So, in the absence of more favorable provisions in favor of the employee, you just follow the twin notice rule, which is the ones stated in King of Kings Transport versus Mamak. You follow the rules there, and then you will not be lost when you talk about just cause termination.
Okay, there's another question here. It's a bit tricky. So, our employee don't want to work during pandemic, and we need them for production. How to give them disciplinary action?
Um, Bakit stick agad yung pinuntahan natin, ma'am? My question there is, if you go by DOLE Labor Advisory 1-2020, issued in January of 2020, right after the Taal volcano erupted, the DOLE issued a rule that man-made calamities and natural calamities cannot be cause for disciplinary action for an employee who fails to report for work. But take note na kailangan meron ka ngayong proseso. No? Hindi ibig sabihin na wala nang recourse ang employer rather. Ano yung proseso natin dito? Now, you review your DTI DOLE guidelines for COVID prevention in the workplace as well as the relevant IATF resolutions. Ano yung isang option para makapagpa-report kayo sa trabaho? You may provide them shuttle services so that you can actually compel them to report for work. The requirement here is that you give the employees the amount of support that they need, no, for them to be able to report for work without issue before you can actually give them disciplinary action. Wag po nating puntahan ng stick. Puntahan po muna natin anong kailangan ng empleyado natin. Hindi lang po, kumbaga, remember that there is a symbiotic relationship between labor and capital. If capital does not exist, labor cannot be productive and vice versa. So, hanapin po muna natin ano yung concerns nila. Baka naman mamaya wala silang transportation or kulang sila ng pamasahe. No? Ito yung mga bagay na kailangan nating intindihin muna before tayo pumunta sa disciplinary action.
I agree on that one. So, is it mandatory to pay employee on floating status?
This is a question that it goes back to employee practice. The law is silent regarding the requirement of pay, no, but it's deemed suspended yung employment relationship, meaning allowed na i-suspend yung employment relationship habang naka-float sila, meaning yung kanilang BIR, SSS, PhilHealth, Pag-ibig contributions are also suspended provided you can execute the same on your payroll processes, no. One option here is to pay them using their leave credits. If there are no more leave credits to be applied, then they may not be paid dahil silent yung batas dun sa aspetong yan. That's it, Samira.
Okay. There's another question here. For companies with less than 10 employees, are they required to submit a DOLE report whenever they are dismissal with just authorized causes?
Less than 10 employees po does not mean na you are no longer covered mandatorily by the labor code. No, this just means that you are not covered by Book 3 or labor standards. But the just and authorized cause dismissal, it's governed by Book 6 of the labor code. That means that you have to comply pa rin with the required DOLE reports.
Okay. What if what if the company does not follow the 30 days notice of termination?
That is, if you're talking about 30 days notice of termination, you may be talking about authorized causes of termination. No? So non-compliance with the 30-day notice is considered failure of due process on the part of the employer and may be source of a cause of action of the employee. Mandatory po
Okay.
yung 30 days. But that does not invalidate the ground. Hindi ibig sabihin na hindi siya nag-follow ng 30 days notice, hindi na valid yung termination. Magkaiba po yun.
Okay, I have a personal question here on my end. Is poor work attitude a valid ground to dismiss an employee using retrenchment?
um, I will point to one of my favorite Supreme Court cases. No, it's a PLDT case. It's a PLDT case about a lineman who was not, who was not, who had a poor work attitude. Ang sabi ng Supreme Court in that particular case, no, poor work attitude is a ground for non-regularization of employment. No? But as far as disciplinary processes are concerned, may or may not be, depende sa company policy. No? So poor work attitude, it may be a ground for non-regularization of employment, but what's this, for termination of employment for just cause or authorized cause, it's a separate matter.
Okay, thank you. Minda has another question here, which is now that employees are working from home, are notices sent via email acceptable as far as legal documentations are concerned?
We recommend that you still go by post office, registered mail with return card. No, the while we do have the e-commerce law and the rules on electronic evidence, the labor code refers to notices sent via personal service or via registered mail pa rin. So just to be on the safe side, go with registered mail with return card pa rin.
Okay. From anonymous attendee, if an employee forwarded a resignation letter dated 29th of July 2021 and effective 30th of July 2021, we demanded a 30-day notice from the employee, but the employee does not want to. Does the employer hold its final pay until he rendered 30-day notice?
I am unable to give a comment. It seems that it's a specific legal concern. So I would recommend that you discuss this with your counsel of choice.
Okay. Any other questions, guys? We have a little bit of like time. We have 10 minutes back.
Siguro let me just cap the discussion by reiterating that when you talk about authorized cost termination, the requirement is good faith. The absence of good faith is the likely ground for an invalidation of a termination. So make sure that you comply with the requirements of the law, process-wise and internal process-wise and legal process-wise, because this is your evidence that you actually have that good faith. In the absence of any of these elements, then your good faith can be challenged and you may be liable for constructive or actual illegal dismissal.
Okay, another question here. May an employer delay payment of separation pay due to cash flow issues?
Ha, the legal requirement for releasing of a final pay and other pay due to an employee who ended employment is 30 days. No, there is no excuse for non-payment. But that said, employees are also human. If you have a candid discussion with them, baka naman pwedeng magkaroon ng term payments, no? As with most legal matters in the Philippines, lahat po ng bagay na dadaan sa mabuting usapan. So, if you have a candid discussion with the employee, tell them about the cash flow issues of the company, of the owners. This is something that can be, managed appropriately.
Okay. From Minda again. Can an
Mhm.
employee apply for redundancy due to comorbidities?
Balik po tayo, Ma'am Minda, dun sa grounds for authorized cause termination. If it's not a disease that's not curable within 6 months, and what's this? Not prohibited by law or harmful to the employee or to the co-employees, then it may not be sufficient. If you talk about comorbidities, that's diabetes, asthma, all of these things, hindi po siya yung illnesses contemplated by law.
Okay, from Doris here, an employee resigns effective of 13th of August, but she no longer reported since yesterday, though she sent a message last Saturday that
Um,
she will no longer report.
this this is when you talk about a whole process, number one, you establish your process first in the company. Some BPOs have a number of days before it's considered no call no show. That's sufficient for the AWOL process to kick in. Make sure that you document it, no, because if you do follow the King of Kings transport versus Mamak, there are 2 notices required. Then that's the time that you may dismiss an employee for AWOL, no. And take note that um, just being terminated does not invalidate an employee's right to process clearance. Kailangan nyo pa rin pong i-process ang kanyang final pay, kailangan pa rin pong i-process ang clearance, no? So you just go by the internal process or policy you have for a wall, follow that documentation, and then you process the final pay as would be regular. Dahil dismissal of employment is also the same as termination from employment, even if it's a resignation. At the end of the day, the employee is still entitled to the final pay and the prorated 13-month pay, assuming entitled siya sa 13-month pay. Okay.
Okay, from Amy here, can an employer remove a 1 month old probationary employee due to underperformance, or does it need a 30-day notice?
You go to your probationary policy, no? If your probationary policy or your employment contract states that there is a specific number of days for termination, then you follow that, no? Ito yung tinatawag ng ating Supreme Court na contractual due process. If you have a company policy that states you have specific guideposts when you will assess your employees for probationary performance, you follow that. Because if you don't follow that, you will be liable for non-compliance with contractual due process. No.
Okay. There's a question here from Benjamin Espanol. What if illegal dismissal is proven against an employer? What is the consequences a company may face?
Illegal dismissal, no. There are, of course, the first one is back wages and or reinstatement. An employee who was illegally dismissed may ask for the payment of back wages or reinstatement, no, kung gusto pa nung employee na bumalik sa trabaho. And the company may also be held liable for moral damages, attorney's fees, and penalties for non-compliance with due process. So lahat ng ito kailangan hingin sa ating friendly NLRC. So if you have a complaint against your employer for illegal dismissal or constructive dismissal, you go to the SENA help desk first. You file the complaint there and then you go through the processes before sila maging liable. Hindi po automatic ang liability ng employer. Kailangan silang mahatulan ng NLRC or ng labor arbiter.
Thank you. Okay. We have a lot of questions here. Let's
Yep.
hold it.
Let's max out the time.
Yes. Is the employee who is about to terminate required to transfer his or her skills to the one who will replace him or her? What if asked by the employer?
This sounds like there is a notice period. Kung authorized cause yung termination ng employment natin, there really is a 30-day notice. Meaning, in that 30 days, the employer can ask for a transition out. But if valid yung ating authorized cause, meaning meron tayong good faith and meron tayong in-apply na automation, labor-saving device, etc., all of these actually negate the requirement of transition. Kasi nga, mawawala nga yung trabaho eh. So, bakit ka magta-transition?
True. Okay. Another question here. For employer asking for background check of a terminated employee, what is the proper way to answer them?
This is a good question, ma'am. For the process here, no, is a general rule before an employer or any entity for that matter who has personal information of another person in its possession, there has to be consent, no. So if you do not have the consent of the employee to release their personal information, you do not do it. You do not release the background check. So this is what I did when I was in government. No, whenever we receive requests in our department for employment verification, the first question I ask is, do you have a signed consent form for our employee to share their personal details with you? If they do not have that, if they are not willing to share the signed consent form of the employee, then you are entitled to not share anything. Okay, that's the first guidepost. Second guidepost, if you receive it, you check it out, and then you do the extra due diligence to make sure that it is a valid signed consent form, then kailangan specific yung tinatanong. No? Kung ang tanong nila is only employment, was Juan de la Cruz employed with your company for position ganito and for the period ganito, then yes, no lang naman ang sagot nun. That's how I would recommend you do it. And better option is you actually implement a data privacy and protection policy in your HR department.
Okay, another question here from the chat for Genevieve. Can an employer terminate an employee if she is pregnant and in the first place the employee did not inform during her interview? Her maternity leave will cause a lot of cancellations of classes, which definitely affect the operation.
Um, let's put it this way. A pregnancy is not, a ground for termination of employment, whether just or authorized cause dismissal. Number two, the law specifically protects pregnancy as a protected condition. Bawal pong mag-discriminate for a person who is pregnant. So, what was the exact question there, Samira?
Sorry?
What was the
Hello?
exact question dun sa sa pregnant?
Can the employer terminate the employee if
Mm.
she's pregnant?
Yan. So ayun, I think that answers it, no. If the pregnancy per se is not a ground for termination of employment, it has to be either just or authorized cause of termination that a pregnant employee committed para maging lawful in termination. If there's no just or authorized cause, hindi po yun pwede.
Okay, I'll go ahead and check out our last question for today. Hold on, let me check. Can an employee refuse to issue a COE for terminated employees?
No. Very simple, no. This has been a very maingay na topic in the Philippine HR group, Facebook group. A COE only contains very specific information. Number one, the name of the employee. Number two, the dates of employment. Number three, the positions held. No, sometimes compensation, but I personally do not uh, advise putting the compensation details in a certificate of employment. Pwede kang maglagay ng disclaimer doon na this certificate of employment is not evidence that employee has been cleared of any and all accountabilities with the former employer. Period. A COE is right it can be rightfully demanded by an employee regardless of the circumstances kung paano siya nakaalis dun sa kumpanya niya. Okay, so if you are the HR, you are allowed to put a disclaimer, but do not put anything libelous there, because if you put something libelous there, you may be liable for such act. This employee was terminated due to theft. You know that that's a problem for you as the signatory on the COE. So you just put it disclaimer. It's not evidence of clearance, no, or it's not evidence that the employee has been cleared of all accountabilities.
All right, and that's about it, guys. That's all the time that we have to answer all your questions. So apologies for those who hasn't been answered, but thank you so much for dropping in your questions here, and thank you to our investor for answering all the questions. above. So,
Thank you.
fortunately, again, guys, that's the only thing that we have. But I'd like to thank you for everyone for dropping by. So, for any e-certificate request, you may follow the instructions that you see on your screens and send your request through this link, bit.ly dash certificate request form, or you can just go ahead and scan the QR code there. Okay. So the moment that we've all been waiting for, sure you guys haven't forget about this. The raffle that we have earlier, I'll be announcing the winner for the raffle. Okay. Her name is Rebs, Rebz, at Eon Flux. Again, I'll repeat her name. It's Rebs at Eon Flux. All right. So just go ahead and wait for our DM. We'll be having a direct message for you to be able to claim your Grab 200 peso load. Okay. All right. Then guys, thank you so much for dropping by and happy Tuesday. Don't forget to please follow us on our social media pages and use hashtag HR Sprout HR Experts to be updated on our events. So again, see you guys on Thursday. Thank you and stay safe.